think of the legal processes that are in place for non-lawyers. This Royal Court of Justice is where we are now headed. We lost in Central London County Court. Then the House of Lords had its first case on Article 8, London Borough of Harrow and Carsey. By a majority of 3 to 2, they ruled in effect that Article 8 could never affect the outcome of possession actions. I'm simplifying. For the law, please go to session number 2. I'm just going to give you a very broad brush approach to the development of the law. Lambeth, after Carsey, duly applied to strike out our Article 8 offences successfully. We appealed. That was joined up with the appeal already in the Court of Appeal. As you all will know, we lost in the Court of Appeal, despite being joined by Jan Luber to lead our teams and our efforts. And headed on our way to the House of Lords. As far as the community is concerned, my earlier point applies square. As soon as you get into the appeal courts, your clients are nowhere. Whereas, at first instance, the issues that are being dealt with by the judge at least bear some relation to their lives and to the issues that are important to them. Once you get into the appeal courts, they're abstract arguments about legal rules. It's not to do with them anymore at all. When I went to chat with the case, Sonia Kay said she went along to one of their appeal hearings, hated it. She said they were talking about us as if we were numbers, and it felt weak, and she had a way back. By the time we got to the House of Lords, there are 11 arguments. We've been whittled down to 3. The Article 8 argument and Kelvin Rutledge's technical arguments around the leases. When the arguments were over, we had a post-mortem in Garden Court, at which the general mood was quite cheerful. We thought wrongly as it turned out that we actually swung it on Article 8, and that the House of Lords were going to give some real force to the right to respect for the home. I was the gloomy one of the party because we knew Kelvin's technical arguments were lost. Lambeth hadn't been called to reply to our argument. And that was actually the last chance for good result for my clients. Article 8 would only ever get them delay. It was their last chance to have security in their homes. It wasn't a happy case for my clients. At every turn, at every step, at every hearing, we lost. After the House of Lords judgments, Lambeth were able to obtain possession orders against all the 60-odd households still affected. Nearly all of them have now gone. That's the flat of one of the parties that was in the House of Lords case. It was evicted in 2006. It's been squatted again since. After that, I asked for volunteers to go to the last step, to the European Court of Human Rights. I had to explain it would do no one any good, it wouldn't prevent the evictions. The most that could be expected after a number of years was a derisory sum in compensation and dubious satisfaction having helped in the development of the English law. Nevertheless, 9 of them did step forward, including Gavin Kay, and David Watkinson and I made our application to Europe. As you know, the European Court of Human Rights procedure has the equivalent of a permission stage, the admissibility stage. We were waiting for the admissibility decision still, when the case of Doherty and Birmingham City Council appeared before the House of Lords, their third crack at Article 8. You may remember that their lordships, attempting to grapple with the effect of McCann in the UK, which had been decided between the argument and the decision, did so in part by abusing the European Court. Lord Scott in particular said, "I consider the McCann judgment to be based on a mistaken understanding of the procedure in this country." Elsewhere, he said it involved a misunderstanding, that it was based on an imperfect understanding of English law or procedure. Lord Hope joined Lord Scott in regretting the absence of an oral hearing before the European Court and attributed to it a lack of understanding of the effect of its own decision. I thought the European Court might enjoy these statements, so I sent the judgment to the Court with the latter, pointing out the relevant passages and saying, quote, "I suggest that in considering the admissibility of care in the UK, the Court may wish to take into account the opportunity it would provide to state the Court's position in relation to these issues." I'm not saying it made a difference, but we were through the admissibility stage, rolled up for a full hearing within 2 months. And finally, on 21st of September 2010, we received the decision. 10 years after the case started, having lost at every stage up until then, at the bitter end, a little bit of sweetness for my clients. €2,000 apiece is worse than nothing, better than nothing. But that's not the most important thing. Of course, what was important was the European Court clearly and decisively said that the majority in the House of Lords had got it wrong. I'll quote from the words in the judgment first used in McCann, because they are stirring words and worth repeating. The loss of one's home is the most extreme form of interference with the right of respect to the home. Any person at risk of an interference of this magnitude should in principle be able to have the proportionality of the measure determined by an independent tribunal in the light of the relevant principles under Article 8. Notwithstanding that, under the domestic law, his right to occupation has come to an end. This is actually the other side of the coin to my gloomy assessment of our role as lawyers. Here is an arena where what we do really does make a difference. We can use our professional skills in order to try and influence the development of the law. And so we come to Manchester City Council and Pinnock. There's been a lot of discussion of Pinnock, but to my mind not nearly enough celebration. I take credit, of course. After a long, hard struggle, after innumerable county court and Court of Appeal decisions, and 3 House of Lords cases all against us, here at last, after 10 years, the Supreme Court has given real effect, quite generously given real effect to the right of respect for the home. So that it provides defence of last resort for everyone. This is a fundamental shift in English housing law towards a sort of basic decency, which is what at its best human rights is all about. I'd like at this point to pay tribute to Jan Luber, who's led the fight at every step of the way. At one stage it seemed that he might not actually be there at the death in Doherty, but I was very glad to see the Equality and Human Rights Commission saw sense, did the right thing and instructed him as interveners. Last of all, I'd like to pay tribute to Gavin Kay, to Jerry Barnett, Ian Constantine and Chris Cole and all the others, my clients, as I told them when the decision came out in Pinnock. This result does not help you or any of the other people who have fought Lambeth, but for the future, in part because of your persistence and resolution, English law has been changed decisively in favour of people keeping their homes.